Ms. Stenger, good morning.
Good morning, Your Honor. Susan Stenger on behalf of Appellant Cheryl Craven-Ansin. Here with me today is my partner, Nancy Van Tyne. May it please the Court. Your Honors, this Court has drawn a solid line between the status of married and unmarried persons in the Commonwealth of Massachusetts. In the DiMatteo case in 2002, in adjusting the standard for prenuptial agreements, this Court said that separation agreements entered into upon divorce are different from antenuptial agreements. And on the termination of marriage, looking at a separation agreement, it's entirely appropriate that the statutory factors in Chapter 208, Section 34, govern the award of property and support and should...
Here, when they entered into the agreement, I understand that was 11 years after they were married.
19 years, Your Honor.
19 years. Didn't they make full disclosure?
No, Your Honor, and that's a key factor in this case. The husband, when they were married, had an interest in family entities that owned raw land in Florida. The couples had a financial manager for many years, and every year they would go in a few times, and on their financial statement, these properties were listed at a value of about $4 million. That figure never changed from year to year. When the couple were negotiating the prenup, the wife twice asked the husband for more information about those entities, and it was the biggest asset in the marriage. She asked for more information. He refused to give it. She asked for it in...
I'm just reading from the agreement. The parties have each had independent legal counsel of their own choosing prior to the execution of this agreement, and each party acknowledges that they have been fully informed of all rights and liabilities pertaining to this agreement. Each party executes this agreement freely and voluntarily and states that the execution by each party is free from coercion.
Your Honor, that provision does not prevent my client from relief in this case for several reasons. One is that in the cases we've cited on disclosure of financial information under a fiduciary duty which spouses owe to each other, withholding information is a breach of that fiduciary duty, and the other side's having reason to know that they're not fully informed does not excuse that breach of fiduciary duty. The other thing is the contract also includes a provision where the husband expressly warrants and represents that he has disclosed all his assets and the approximate value of those assets.
So, Ms. Stenger, let me ask you this. One, I take it from this argument that you are not opposed to postnuptial agreements in every circumstance, correct?
Frankly, Your Honor, we are making the argument that they should be void as against public policy in all cases. While there may be a short list of situations where they would be appropriate, most often a postnuptial agreement is going to be asked for by the spouse with the greater financial leverage in the marriage and using emotional leverage against the other spouse to get them to sign.
Well, let's assume we don't agree with you on that, okay? Let's assume we don't agree with you on that. It seemed to me that your second backup argument that you were making is, as in connection with any contract, if there's material misrepresentation, you can set aside the contract. Why would that not protect your client in this circumstance?
We have made an argument that failure to disclose the abject refusal and blindfold willness on the part of the husband here to get the information that was available only to him on this property is a grounds to undo that contract. But in the bigger picture, looking at postnuptial agreements, there may be situations where it's not about the value of an asset, but more the big picture. What percentage did the spouse with lesser leverage get of the marital estate? Was there any support awarded? Here, there is no alimony awarded.
But there's $5 million and a lot more than that on top of it.
$5 million may seem like a lot of money to you or I, Justice Botsford, but it's not a lot in the context of this marriage. If you look at the information we have of what was the actual fair market value of the interests of the properties in Florida, she got 16% of the total marital estate. If you take the Florida properties out of the value of the marital estate, you would think if that was his issue, if that's what he wanted, set those aside, she gets 50% of what's left. No, she got 33% of what's left and no alimony.
Well, let me ask you this. She didn't have to sign this thing, did she?
Justice Ireland, the idea of coercion, I know in a commercial context, the hurdle is high. You have to show the gun to the head, so to speak. In a husband and wife relationship, and I've cited case law on this, the idea of coercion is a much lower hurdle. Emotional coercion, taking advantage of strife in the family to increase one's financial situation.
Is there a finding of fact that there was no such coercion here, though?
The judge's finding is a conclusory finding. If you look at the underlying findings she made, there is enough there, Your Honor. And what was most crucial in this case was that one of the parties' children had mental health issues, and he was suicidal, and the husband recognized that in testimony. He left a job, he sold a company in New Hampshire so that he could spend more time at home. The wife was concerned that if the husband left, that it would be too much for this child to bear. And that was her main focus in trying to save this marriage. It was not about, she was not focused on money. And you know, that's one reason these postnuptial agreements are different than separation agreements, is that when the parties are actually getting divorced and they reach the point of negotiating a separation agreement, other than issues involving children, it's essentially a dissolution of a partnership and simply
but I thought
financial.
you said this was it was more like a separation agreement than it was an anti-nuptial agreement, didn't you?
Absolutely, absolutely. And that is why if postnuptial agreements are going to be allowed in Massachusetts, the higher standard for separation agreements is the standard under which postnuptial agreements should be reviewed.
Well, what if this had been, what if the marriage had gone on for 10 years, some business need to sort of separate assets, and it had gone on for 10 years? It really wouldn't be anything like a separation agreement at all.
2 points to that, Justice Cordy. The one example where a postnuptial agreement might make sense is where one spouse wants to invest a lot of the marital assets in a risky business venture. And so the other spouse is against it, but says, well, all right, but if anything ever happens, you know, that's on your side of the equation. That might make sense.
Or pledging assets in some way in which they want to make sure that the assets are severed from the marriage so that they are,
right.
No challenges.
Right. But the reason it doesn't make sense in looking at a number of years is that what happens during those years, we cite a Minnesota statute, for example, that says you can't file for divorce for at least 2 years after signing a postnuptial agreement. But I submit that a certain time limit has to be looked at on a case-by-case basis. A limit doesn't work because within that 2 years, the parties could live completely separately. One party could be subject to physical or mental abuse, or there's no. If they've had strife in the marriage, there's no effort to reconcile and go to counseling. And the spouse who got the financial advantage out of the contract is simply biding their time for that minimum time period. What makes much more sense is to have a contract reviewed as to whether it's fair and reasonable at the time of divorce, as separation agreements are reviewed.
But didn't the judge here say, if this were a separation agreement, I still would have approved it?
Yes, Your Honor, and I think that is clearly erroneous. It's not even a finding, it's a conclusion on her part, and I think it is in error. If you look at...
If you apply the Section 34 factors, it's
exactly.
probably an error.
And one of the main Section 34 factors is the estate of the parties, which means their assets. And she cut Mrs. Craven-Ansin off at the knees every time she tried to get information about the key asset.
You know, back to my question about whether she was required to sign this, there is a statement in the agreement. Each party has executed this agreement specifically having been fully advised of their right to refuse to do so. But your answer to me is she was coerced because of the child. But the judge didn't make that a finding, did she?
The judge made the finding about the pressure that the wife was under, but she did not conclude from the subsidiary findings that that amounted to coercion.
And are you suggesting that's an erroneous finding?
Yes, I am, Your Honor.
Erroneous conclusion.
An erroneous conclusion, which this court looks at de novo.
How many children are there of this marriage?
There are 2.
And I assume all the evidence that you've been telling us about the child and the father leaving his job, that was all presented to the judge?
Yes, it was, Your Honor, because everything I've cited in the brief came from the trial exhibits and testimony.
Now, am I correct in understanding that virtually all of Mr. Ansin's assets were inherited by him, were obtained by trust, as opposed to being obtained through his efforts, which she may have helped to
Correct, Your Honor. And he, as I understand it, got his interest in those entities prior to their marriage. I mean, I think he might have been a teenager. It was something set up by, or perhaps from birth, I don't know.
Okay, so this is not a case in which she can say, I took care of the home while he was allowed to work, and therefore the fortune which he obtained through his employment is in part through my efforts. This is not that kind of case.
I disagree with that, Justice Gansett. The case law on contribution, which is one of the discretionary factors under Section 34, he took care of those assets. I mean, he attended meetings, he was involved in them. The wife made extensive contributions early in the marriage, and I've cited these facts. She was the one working while he was in college. She paid the household bills. She paid the uninsured medical bills for her pregnancy. She worked for many years. She later worked for his cabinet company. She took care of the home. Those are all contributions in a marital partnership, which is how this Commonwealth views marriage. And simply because he inherited that prior to their marriage doesn't mean that it didn't become a marital asset and part of the pot going forward.
Ms. Tanger, forgive me. Was there an event that triggered the husband's wanting to enter into a postnuptial agreement?
The only hint to that, Your Honor, is that when he called the wife and told her that he needed, was his word, he needed a prenuptial agreement if he was he needed a postnuptial agreement if he was to stay in the marriage. He made that phone call from a quote-unquote business trip in Florida. The only business in the record he had in Florida was his periodic meetings with the family about their Florida real estate holdings.
Is the real estate holdings, this is a minority interest? I think that Mr. Ansin argues that in any event, this minority interest is fairly inchoate and very hard to value. And what do you say to that?
Well, Your Honor, he admits in the record, or perhaps it was in his interrogatory answers, which are a trial exhibit, that it's raw land, there's no mortgages on it, they haven't made any loans from it. It's a very simple asset. The only complication is that it's held by a corporation in which many cousins and family members have an interest. But he has a set, I think his interest is 12%. He has a set percentage interest of a very simple collection of real estate holdings.
I thought there'd been a lot of development.
Pardon me?
I thought there had been development of this.
It's all raw land, Your Honor, according to the record. And so, in that sense, they're simple. Now, I understand you can't go out on the open market sometimes and sell your 12% in a family business. Right. That being said, an expert could calculate the appropriate discount for that value. The value on the in the agreement and in their periodic financial statements was just over $4 million. The tax assessing records were $12 million more than that. And in Florida, the law is that tax assessments should approximate fair market value.
So who is to pay for that rather difficult valuation? I mean, I guess that there's no income from this trust unless they sell part of the property, so they could have gone 20 years without selling.
But they didn't, Your Honor. If you,
I know they didn't, but
yeah.
But going into the future, I gather right now it's probably not a great market in Florida to sell raw land.
Right.
I guess my question is, who's to pay, in your world, if you are to do a postnuptial, who's to pay? Whose responsibility is to pay for that valuation?
Your Honor, simply because an asset is hard to divide doesn't mean that the divorcing spouse gets a share of it as part of the marital estate. Sure, there's a difficulty, but there are various ways a probate judge could deal with that. One, the husband gets financing, buys her out. Two, she's given a percentage interest in the property. Three, she gets a percentage of income as it's received by him over the years. I mean, he did get a lot of income year to year from that property. And in fact, one of the corporations, the Cleghorn Corporation, in which he had an interest, was listed at a value of just over $1 million in 2004 in the postnuptial agreement. Yet in 2005 and 2006, he received distributions from that property of about $6 million.
And she received the distributions that occurred from the date of the postnuptial until later on, right? I guess there were
Under
sales
under
made,
the
and she received a
agreement,
share of
yes.
that.
Yeah, under the agreement, she got 30% of any of that money that
But
came
I'm a
in
little
during
bit
that period.
perplexed. I mean, one gets the sense that it was important to Mr. Ansin that she not become a part of this family trust, that the family did not want her to be a part of the family trust, which means then that they would have to, at some level, buy her out, but that means a valuation, and who's to pay for that valuation?
I think it's the husband's job to pay for that valuation. It shouldn't be her job. He had the obligation to disclose the value of his assets.
Thank you, Ms. Stenger.
Thank you, Your Honors.
Mr. Lee?
Good morning, Your Honors. May it please the Court, my name is David Lee. I represent the appellee, Kenneth Ansin. My partner, Kevin Kaur, is with me. The question that's posed before the Court in this case is whether or not married persons have the freedom to contract with each other.
Well,
And
let's
if there
just
is
assume that they
limitation-
do.
And if there's limitation, what is the state's interest, really, in any way affecting that right of them to enter into contracts with each other? This Court has made it very clear, going back to 1976 in the case of Knox versus Remick, that in fact there is no reason why it is that people, in anticipation of the termination of their marriage, can't freely enter into contracts with each other. And this Court made a determination.
There are two important state interests right off the bat, right? And you would recognize both, and I'm sure you just accept them. One is children, child support. So you're saying take that out, correct?
That's in Knox and Remick.
And the second is not having somebody become a ward of the state, correct?
That's enforceability.
So-
That's enforceability.
So you're saying that other than those,
No.
the state has no interest?
No, I think that this Court has made it very clear the state has an interest. And the interest was spelled out in the DiMatteo case, where the Court clearly said that the agreement has to be fair and reasonable at the time it is entered into. There has to be general knowledge of the financial circumstances of the parties, and there have to be clear waivers. And this is really no different from what it is that the Court said in Knox and Remick with respect to a separation agreement. It said the terms of the agreement have to be fair and reasonable. There has to be an expression of finality, and it has to be free from fraud and duress. So the state interest is really to make certain that the process of entering into the agreement is one which is fair. The terms as they existed at the time the agreement was entered into.
What would happen in this case? Because there is another interest, which is the contribution of a spouse who's the non-financial contributing spouse. What would happen in this case if she had, for whatever reason, after all the disclosure, had given up all right, title, and interest to any property that he had?
I think, again, the Court made very clear in DiMatteo that the standard of fairness and reasonableness with respect to agreements of this sort is that you not vitiate the status of marriage and that there not be essentially a stripping of one's entire marital rights or marital interests.
But isn't
And in this
disclosure
case-
part of that?
I'm sorry?
Isn't disclosure part of what makes it fair and reasonable?
Certainly. And again, this Court in DiMatteo has indicated the type of disclosure that is required. The type of disclosure that is required is not something that is consistent with precision or appraisals or a definition. Rather, it is
might be in
general.
certain cases.
Sorry.
It might be in certain cases.
Well, I think that the standard this Court has said is that there has to be general and sufficient knowledge. In the DiMatteo case, what this Court said was that one has to have sufficient knowledge of the financial circumstances in order to choose to enter into this agreement. This Court cited the Colorado case of Lopato versus Lopato.
No.
In that case, there was no financial disclosure. There was just an acknowledgement in the agreement that, in fact, the parties had had disclosure of the financial situation, and they then waived any right to further disclosure or information, and even stated that, in fact, it was irrelevant to the terms that they came to with respect to the agreement. And in footnote 19 of the DiMatteo case, this Court said that, in fact, the standard as set, referred to, I think, in Kindred and Inker, their publication, that, in fact, if there's sufficient basis to make a determination that one wishes to enter into this agreement, that is sufficient financial knowledge.
Mr. Lee, can I just get some facts straight?
Yes.
The agreement, the post-nuptial agreement, concerns the Florida properties?
The postnuptial agreement concerns not just the Florida
Florida
properties, Your
property.
Honor, and that's a critical issue that you just hit on.
Okay. So he has, in 2007, income of about $5 million. I take it that's annual income.
No.
It
I
says
don't
his
think so.
gross yearly income, I'm looking at her factual findings, 126. Gross weekly income is that his gross yearly income was $5 million. I was having a hard time figuring out.
Which finding was this?
126,
This was, I believe, in
2007. And his assets total 16 million, not including value of the Florida properties.
I think what you're referring to is that his income in 2007
Yeah.
had been at that level.
Yeah.
That was not his income every year.
Was that because of a distribution
Yes,
from the
that was
trust?
because of a distribution that came there.
Okay.
And getting back to your point, Chief Justice Marshall, the agreement was not just about the Florida properties.
Okay.
And critical, I think, in this case, is the fact that there was contemporaneous consideration that was received. Ms. Craven-Ansin was represented by one of the premier family law firms in Boston over the course of time that this agreement was negotiated. Both counsel representing her at that time testified that the intention in her representation of Ms. Craven-Ansin was that there be a binding postnuptial agreement. Ms. Craven-Ansin herself, at appendix reference page 266, lines 18 through 23, stated definitively that when she entered into this agreement, she intended that her husband be bound by the obligations. And what were the obligations that were set forth in this agreement? The obligation was to provide her, in the event that there was a divorce, with $5 million. Not a reduced amount if his assets declined. $5 million of certainty. And in addition to that, she was given the option of taking it in cash or taking it in property or taking it in both. There's nothing in the law that says that someone who is married is entitled to a commitment that there's a certain sum of money that they will receive in the event that there's a divorce. That was negotiated by her counsel for her. In addition to that, a $2.5 million life insurance policy was provided for her, not merely through the period of time that they were married, but for the rest of her life if Mr. Ansin were to die before she, and even if she remarried.
What about the disclosure? What about the disclosure? Are you arguing that he made sufficient disclosure?
I am. And I think there's a
On
specific...
what basis?
On the basis that there's a financial statement that was appended to this agreement identifying all of the assets of these parties. And in fact, I'm not sure whether it's clear in the record, but the statement said that this was a net worth statement of Cheryl and Kenneth Ansin. This was not just a statement of Mr. Ansin representing his assets. It was a joint statement that was prepared by their joint financial advisor, who had been meeting with them regularly since, I believe, 1991, and this statement was signed by both of them. This was not
But
an
Ms.
individual
Stenger
statement.
says that this was just a very general appraisal.
It used placeholder numbers.
Only
for
used
these-
pla-
Well, it did. It used placeholder, not actual numbers for the Florida properties.
It only used placeholder numbers for the Florida property, correct.
That's the
But
issue.
if you look at finding number 49 made by this court, made by the trial court, the trial court's finding number 49 said that by the beginning of July of 2004, before this agreement was entered into, Mrs. Craven-Ansin was satisfied with the extent of the information that she had about the Florida properties.
Was there
and
anything
she
in the
was prepared
record?
to go forward.
Is there anything in the record that indicates that her lawyer at the time had done any research on the value of the property in Florida?
There is no indication in the record, Your Honor, that her counsel or she had chosen to take any steps independently to determine a different value or a value. What happened in this case, and I think the evidence shows, and certainly the transcript shows, was that these people consistently carried with their joint financial advisor, with whom they had worked since, I believe, 1991, that they carried it at a fixed value based upon the recognition that it was nothing more than a potential stream of income. There was about a 12% interest that Mr. Ansin had in these properties, in these businesses, and that's critical, because there was never any effort on the part of Ms. Craven-Ansin to introduce at trial any evidence as to what it is that the value was of the ownership interest that Mr. Ansin had in these business entities which happened to own property.
Is there anything in the record that indicates that the defendant was aware of the assessed value of the land that was held by these corporations?
There is nothing to suggest that either the plaintiff or the defendant had any knowledge of the assessed values of these properties.
From where did the placeholder numbers come?
There was no clear indication as to where the placeholder numbers had come from, other than through communications with the financial advisor of the parties.
Was
and
the
the
financial
parties,
advisor the tax preparer?
I believe that he did prepare their taxes, Your Honor.
Well, one serves very different functions if you're a tax preparer than if you are, a financial advisor for purposes of determining a real value of property for disclosure purposes in a post-nuptial agreement.
Well, I don't think that there was evidence that this person, Mr. Rivoto, or his predecessor at Minette, was the one who made the determination as to what value to
No, but I mean,
assign.
there's no reason why, if it's not generating income, you have a placeholder in there, and from his point of view, that's fine.
But I think that's because of the fact that there was no means by which anyone reasonably could assign a value to this interest, and both parties recognized it, and the trial court so found.
How did they do it later?
How did...
My understanding is that she challenged that as a, quote, real value. Correct, accurate valuation. I mean, if they were...
There was no evidence that was even purported to be offered to indicate that there was a value any different from the $4 million. The argument...
I thought the tax assessments, somebody looked at all the property taken together had this assessed value, divide by 12% interest.
That's not a measure of value of a 1/12 interest.
I understand, but wasn't that the evidence at the trial? Wasn't there some evidence?
No, it was not able to be introduced into evidence.
Well,
That
so
was
it was
something that was
offered.
precluded.
I mean, there was an effort. It's the judge wouldn't allow it in, right?
There was an effort on the part of Ms. Craven-Ansin to introduce evidence as to what it is that the assessed value of the real estate holdings of these business entities were, which I argued was not relevant because there was never any proffering or suggestion of proffering of any evidence as to what it is that the value was of the interest that Mr. Ansin had in what it is he owned, which was not the land, which was not the raw land, and there was never any suggestion of evidence that would be introduced as to whether or not there were any liens on the properties or what it is that the business expenses of the properties were, et cetera, et cetera.
Is your argument that at the time that the post-nuptial agreement was negotiated, is your argument that Ms. Ansin didn't insist on Mr. Ansin giving more information about the value of the Florida interests, or is it that they couldn't be valued anyway? I mean, if she hadn't, well, which is it?
The answer to that question, Justice Botsford, is that in fact her lawyer had requested information. When we inquired as to whether or not she had had conversations with her lawyer as to the full extent of what her own knowledge was about some of this land that was owned, she claimed the attorney-client privilege and consistently claimed that privilege.
But what happened when her lawyer requested the information?
The
This is back
information
at the time it's being negotiated, right?
at the very beginning,
Yeah.
her lawyer asked for some
And
disclosure
what was your response?
about that. And my understanding, it wasn't my response, but my understanding at the point in time was that there was not information that was provided, but there was never any suggestion that Mr. Ansin had any information to provide. And in fact, the evidence was that it was Ms. Craven-Ansin who had the financial statement from the financial advisor with whom the parties both met quarterly over a period of years, who gave the information to her own lawyer. And then through the course of the evidence, the trial court made the determination that in fact, as of the beginning of July, this had become a non-issue.
So you're saying
And that she had sufficient information.
it's waived, I mean, in substance, is that what you're saying? That
I'm
it was
saying
waived as
that-
part of the negotiations?
I do say that.
Mr. Lee, could I just ask you this, from our point of view, given what we've said about the importance of marriage in a society, should it make a difference if the reason why somebody is entering into a post-nuptial agreement is because one or other spouse is threatening to leave the marriage if they don't do it, as opposed to some set of circumstances that are not triggered in any respect by a threat to leave? Let me give you an example. Wife has wealthy uncle. Uncle says, I want to leave you $16 million. but I want it for your use and then to go to your children, let's say they're children of a prior marriage. I mean, any kind of thing like that. It's got absolutely nothing to do with the relationship between the spouses and no threat to leave. Should we view it any differently, or is it your position any postnuptial agreement, as long as it's, meets the DiMatteo test, is okay? We don't look to the reason.
That is my position.
But
And I think for
isn't
good
there a
reason.
problem, though, that then someone will just use the subterfuge, or won't be honest about it? I mean, if the law is one thing and the husband knows that he's going to get harmed if he indicates that he wants an agreement because he's thinking of leaving rather than for some other reason, then isn't there just going to be deception?
Well, I think not, Justice Cowan. I don't think there's anything that really supports that. Quite frankly,
Well, here, isn't it quite clear that he didn't really, I mean, it seems to me, you don't have to ferret very far to figure out that he wanted this agreement because he was thinking of getting divorced.
I don't believe that. And I
What
don't
was
think
the
that the
time
evidence
period-
supports that.
What was the
evidence
time
doesn't support
period
that.
between the signing of the postnuptial agreement and when?
Post- The
15
postnuptial
months?
agreement was signed on the
16
24th
months?
of July, 2004. Ms. Ansin requested that my client leave at the end of May of 2005. He left in the beginning of June of 2005 with the evidence being clear that he did not want to leave, and that in fact for a period of time until November 28th of 2006, there was no divorce filed by either of them. And the trial court found through the testimony of Mr. Ansin that he didn't want the marriage to end.
Would it
And that
make
there was-
sense? I mean, I take it that one of the concerns that Minnesota, at least in other states, have had is if somebody is using a postnuptial agreement fully intending to leave the marriage, knowing that in the absence of a postnuptial agreement, what we would call Section 34, difference in other states, would entitle the remaining spouse to far more property and income. You just say leave that to the trial judge to ferret that out as a motive?
I believe that that's what the safeguard is. A trial court can make a determination with respect to Justice Cowan's question as to whether or not somebody was sincere or somebody had a different agenda.
Was
In
there
this
any-
case, the trial court found that Mr. Ansin was sincere.
Was there any evidence as to why he wanted the postnuptial agreement at this particular time?
Yes. The parties had, in fact, had marital difficulties. It was all spelled out without my going into it here in
Sure.
the record. Ms. Ansin had asked him to leave in February 2004, I believe. Mr. Ansin was concerned about Mrs. Ansin's commitment to the relationship, and Mr. Ansin was as well concerned, given his concern about Mrs. Ansin's commitment to the marriage, about this issue of that which he had from the time he was a young man, or a young boy even, with this particular
But
property.
so in essence, then he wanted the agreement because there was a possibility of divorce in the future.
There was a
in the near
possibility of divorce in the future, but that's not a bad reason for people to be able to enter into agreements. And this goes back to Chief Justice Marshall's question. It should be available in both the circumstances that she identified, not only the estate planning circumstance, but also the circumstance of the possibility of divorce. Because we don't want to just leave people with the option of getting out of a relationship or staying in a relationship, because too many people may choose getting out. This court, in the case of Caffin versus Caffin, made the determination that the legislature, by reason of putting in no-fault divorce and not requiring there to be any objective standards as to whether or not there's an irretrievable breakdown of the marriage, said anybody who subjectively wants a divorce can get a divorce. Here, with a postnuptial agreement, the option is available to be able to set those terms of what it is that the property rights and interests are of the parties in the event of divorce, but stay together and try to work on the marriage, as was done in this case with the Ansins, continuing in their marital counseling and continuing in all of their time together. The record shows that they went, after the agreement was entered, over the course of months, to Mount Tremblant, to Cabo San Lucas, to San Diego.
Mr. Lee, you had mentioned a minute ago that, if I understood you correctly, that counsel for the defendant, during I believe the trial, was sought to introduce evidence of the assessed value of the Florida property, and you were able to succeed in keeping it out. And in response to an earlier question that I had asked you, you said there's nothing in the record that indicates that they knew what the assessed value was. Let me ask my question in a different way. If we look at this record, will we be able to conclude that the defendant was aware of the holdings of this corporation, of these corporation's assets, aware of the nature of the corporations, and had there been an evaluation of the corporation, she had all the information she needed in order to determine what her husband's value in that corporation was?
I'm not clear as to whether or not she would have had that available. Certainly, the evidence did not suggest that my client had that information available with which to be able to try to make that determination, but there was never a suggestion that they had any information available that they were going to put into evidence to suggest that the value of his interest was materially greater than what it is that was represented on the financial statement, such as to make the information insufficient for her to choose to enter into this agreement, which she so willingly elected to do, as evidenced by her testimony at trial.
Mr. Lee, before you sit down, was there an impoundment order entered in this case?
I'm sorry that I don't know the answer to that question.
Well, I have a brief that says contains confidential information. It's not your brief, but, I mean, is there some reason why the information is confidential?
I don't think, my partner may be able to comment if the court allows. I don't remember if there was one. But they weren't trial counsel.
I'm just a little concerned that,
Can
in
we
any case,
provide that
perhaps we could get a post-argument letter as to whether there was an impoundment letter, who entered it, why they entered it, on whose motion, was there a hearing, did it comply with our rules, and so on and so forth.
We will
Just a
provide
little.
that. Thank you very much.
Thank you,
And
Mr. Lee.
we submit.